law expert has warned of the dangers of pursuing simultaneous impeachments against both the president and the vice president. To talk more, let's bring in Professor Paolo Tamase of the UP College of Law. Good evening, Professor. Thanks for joining us.
Hi, good evening, Regina and everyone, and to your viewers.
Okay, so let's get right to the point. The dangers of simultaneous impeachments against the top two officials of the land. What is the danger here?
I think the Constitution itself accommodates a situation where both the president and the vice president are subject to impeachment proceedings. But if there's any danger, then it's really political in character. You're giving Congress effectively a weapon to use against one or of the two or both highest officials in government. There's also potentially instability in the proceedings, right? Your two highest officials, both the chief executive and the person who can replace the chief executive, are subject to this procedure might end in removal, and so there's that pressure. But on the whole, I think the Constitution that we have accommodates this process.
Okay, but Professor, let's discuss the events that took place today at the House of Representatives. They held their second hearing on the two impeachment complaints of President Bongbong Marcos, although only the first one was tackled today. How high or low is the threshold for determining the sufficiency in substance of impeachment complaints?
My understanding, even based on past congressional practice, it's a low standard. It means, and if you look at the House rules, it only tests whether there are allegations that would rise to the level of an impeachable offense. So we're not talking about the evidence yet. We're not talking about the truthfulness of the statements there, although I think there was some debate earlier this afternoon, or I think late this morning, about whether they would look already into the truthfulness of those allegations. But on the whole, we're just checking whether the acts complained of would rise to the level of such an offense that would render the public officer unfit to continue in office. So it's a low threshold. Usually it's a preliminary step that we're looking into before we actually bother the parties to present their evidence.
But what did you make of the deliberations that took place earlier today? Are you seeing any indicators that this will hurdle this step, this stage, or are you seeing that this possibly could get dismissed?
Just based on the statements that were being made in the committee hearing today, it might be dismissed, at least as to the first complaint. If you want to look closer, I think there's some consensus, at least, that the act of enforcing the ICC arrest warrant against President Duterte did not rise to the level of an impeachable offense because it was pursuant to a warrant issued by an international court. On the other hand, the supposed drug use was solely based on statements made in public and probably in frustration by the president's sister, Senator Marcos. And so just based on these, it might not yet show that the president is incapable or unfit to continue serving as president.
What I want to ask you, Attorney Tamase, is what happens? Let's say they do decide to junk the first complaint altogether. Is there going to be any possible hurdle on hearing the second impeachment complaint against the president from the Makabayan bloc? Because consolidation, I'm not sure if that's still a gray area, or is it not a gray area anymore? What are your thoughts on that?
I think if we look at the Supreme Court decisions, and not only this January 2026 resolution, but the entire body of Supreme Court decisions fairly, there should be no hurdle to hearing the second complaint. It's because these two complaints were referred at the same time to the Committee on Justice. And if we follow old precedent concerning this, then that referral would still just constitute one initiation. So I don't think there's really a serious ground to prevent the discussion of the substance of the second complaint.
Okay, another clarification. Can they just junk certain articles but not all, or is it all or nothing?
That's possible. They can pick and choose which articles to forward. So you have to remember that when this process goes on, the House is not going to endorse to the plenary an impeachment complaint. What they're going to present is a report to the plenary, saying that based on their hearings, these are the impeachable offenses that were committed, or alternatively, that the president did not commit any of those impeachable offenses. So when that gets to the plenary, what is voted on is actually the report. If 1/3 agree to support a report that would recommend the filing of impeachment or to proceed to the Senate for trial, then that would be sufficient. But then again, you're just looking at the report, not at the article, not at the complaint rather that was originally filed.
With the report, one last clarification. When that report goes to plenary, can they vote? Do they have to vote on it like all or nothing too? Or can they take it apart and discuss it in plenary?
I think, and we go by the practice of the House, they would vote on the report in its entirety. Whether they would be able to push through with all articles all the way to the decision to convict or not to convict in the Senate, that would be left to the House's discretion. But ultimately, it's a thumbs up or thumbs down on the report.
Speaking of the January 2026 Supreme Court ruling, we haven't had a chance to ask you, what did you think of it? I know there's been a lot of teeth gnashing in the legal industry about whether or not there was a judicial overreach. And I'm asking you specifically because you teach constitutional law.
That is the phrase of the week, right? Or the weekend, the concept of judicial overreach. And I think it might actually be useful to start with that concept. So judicial overreach just basically says that the court has exceeded the power that it has been granted under the Constitution. And the power is quite clear to any lawyer. It's the power, it includes the power to review grave abuse of discretion, but at the same time, it's still subject to the limits that, you have to respect other branches of government. You have to acknowledge sometimes that they have an exclusive power over certain prerogatives. So my sense is that the decision, as we all know by now, didn't really change the result. And my problem is that while the decision, I think, correctly walked back from a lot of the dangerous language in the 2025 July decision, it still changed certain aspects, which I think were, with all due respect, irregular. So these aspects of the decision or the ruling of the court here seem to reverse some things that they already established in July, and yet the result would be the same. So that's one issue, right? Like with the court's adjudication, are parties given enough opportunity to actually contest the reasons for the decisions for or against them? But I think the larger question that has been looming on many people's minds, and even to my surprise, to even a lot of lawyers' minds, is this a point where the court has overstepped its limitations in the Constitution? And that's a fair question to ask. While we do give our courts a lot of leeway to intervene in the legal and even political processes, impeachment was really just one of those things where it really respected Congress. And while it walked back from a lot of the dangerous language from the July 2025 decision, it still seemed to impose certain rules on Congress, which didn't look like, it was treating Congress as a co-equal branch. So these are fair questions to ask about our system of government. Is the court itself being checked by the political branches?
And one thing that's being debated really is the term session day. I know the Supreme Court has redefined that in their latest resolution, saying that a session day is a calendar day. But as we all know, in Congress, it means different. Should Congress here assert their definition? Can they still clarify that with the Supreme Court? I know that in the SC's resolution, they said it was final. No more MRs will be entertained. But can anything still be done, Attorney?
So 2 points. First, on the legal point, there is no further action on the part of Congress, I think, right? Unless it argues that the resolution in January 2026 was a completely new decision, and therefore it would have some right to file a motion for reconsideration, which is itself a contestable issue. I don't think there's anything that's coming out of the Supreme Court for now. But that doesn't mean that Congress is left powerless. I think you see in the dynamic in Congress some insistence that it is their prerogative, and that despite the court's ruling on this, they might treat that ruling as not really particularly binding on them, especially because if they interpret their power over impeachment or to initiate impeachment as exclusive. But the second thing that to consider is really is the strategic point. Is there a point going against the Supreme Court's particular ruling on the session days or any part of the decision at this point? Remember that the decision in July and in January principally concerned the second mode of impeachment, the one by verified resolution, which is a fast track, express lane type of impeachment. The one we have now involves more tedious hearings, and therefore it might be good to just focus on what's going on in the House now rather than try to, oppose the court by insisting on the process for the second mode.
Attorney, your thoughts on the second impeachment complaint? You already expressed your skepticism as well on the first one. What's the chances of the second one, you think?
I would like to go back to what Congressman Abante said, which, this is an exercise in futility. I don't necessarily think it's a zero-sum game. Even if you have a majority in the House, those hearings may proceed. It's still an opportunity for the complainant to put before the public serious allegations of wrongdoing. And my own sense is if the evidence is strong and the evidence is already apparent as early as the filing stage and the complaint is shared with the public, then Congress itself might be under pressure to show complete fairness when it comes to hearing it. So it's not necessarily 1-0, numbers game. But as to the allegation itself, I would imagine that the main opposition of some members of the majority might be that the president isn't shown to have personal culpability or personal responsibility over the things alleged in the second complaint, and that might well be the point of argument for when they hear the second complaint.
Coming back to the Supreme Court decision, Prof, you touched on something very important, I think. Not that we know the answer, but who checks the Supreme Court, right? What recourse do people have at this point? But we're running out of time, and really my question to you is, do you agree with Senate President Tito Soto that impeachment is now an impossible dream given this new jurisprudence? And I should also add that we spoke to Constitution framer Attorney Rene Sarmiento, who said that this decision basically has emasculated the impeachment as a tool for exacting accountability. Where do you stand on that?
I wouldn't go to say that it's an impossible dream. Maybe in very clear cases, impeachment might still work. But in cases where you actually need to do a little more legwork to show that something's wrong with this impeachable officer, I would agree that it's a lot harder to do it now. And it's because you've opened up avenues for the court to intervene at every stage. And you see how that affects impeachment cases, right? It slows down an impeachment case. It gives either the House or the Senate an excuse to delay the proceeding. And, that doesn't seem to really fit with the original design of this accountability mechanism.
So it has weakened the tool of impeachment as a method for exacting accountability.
Yes, I tend to agree with that. And this is because impeachment is addressed it's not just for the president or the vice president. It's also against officials like the court and constitutional commissions. And there's a lot of language in the recent decision which might slow down impeachable complaints. So for example, you have the court setting rules there for collegial bodies. That was not an issue in the petitions, but the court saw it fit to lay out rules this time that for impeachment in those cases that may well apply to them. So it's certainly weakened as an accountability mechanism.
Is there anything at all that you approve of in the final ruling of the Supreme Court that you think actually has or contributes to the improvement of the impeachment process as an accountability measure?
To the improvement, none. Okay? I'll be very frank about it. And it's really just academic, being blunt academic about this thing. But I think it did cure one problem with the July decision, which is the July decision removed political from the characterization of impeachment. You see the court walking back a bit, right? It says legal, political, and constitutional. And that's basically everything. But the point is that it returned political to the forefront. And that's a small change. It's a one-word addition. But it really sort of walks closer to the original framework. And yet, for all of the reasons we've talked about, I think impeachment still has changed for good.
Well, finally, Professor, talks on charter change are being floated once again. What is your stand on that?
Is it time?
You know, I've never been close to the idea of talking about whether the Constitution is still current. It's important for democracies to actually talk about whether their Constitution is still current and still addresses their people's needs. But there's also some history tells us to be cautious about charter change. It's not to say no to all forms of charter change, but to see the motives behind it. So charter change has been used in the past to extend presidential terms or to concentrate power. If those are not the motives, and if there are fair proposals, then we should talk about them. But the public should be very careful and cautious when we talk about changing our fundamental law, despite what has happened to impeachment.
Fair enough. We shall leave that there. Thank you so much for explaining all of that to us. That was Professor Paolo Tamase of the UP College of Law.